Federal marshals arrived at Trump Tower on Fifth Avenue at 6:47 a.m. on January 16, 2026, carrying court orders authorizing the seizure of one of the most iconic properties in Manhattan. By noon, marshals had also taken possession of the Trump National Golf Club in Bedminster, New Jersey, and initiated proceedings to assume control of the Trump International Hotel in Washington, D.C. This isn't a hypothetical threat or a distant possibility. This is federal law enforcement actively seizing assets belonging to the Trump Organization to satisfy a $450 million fraud judgment that Trump failed to pay or appeal with proper bond. Within 24 hours, 3 signature properties that defined Trump's public image for decades have been placed under federal receivership. The empire built on the Trump name, the brand that launched a political career, is being systematically dismantled by court order. And the legal mechanism making this happen reveals just how thoroughly Trump's financial house of cards has collapsed. This seizure is the culmination of a civil fraud case that began in 2019 when the New York Attorney General's office launched an investigation into the Trump Organization's business practices. Over 3 years, investigators compiled evidence showing systematic inflation of asset values when seeking loans and deflation of those same assets when calculating taxes. The case went to trial in September 2024, lasting 9 weeks and producing over 40,000 pages of testimony and documentary evidence. On December 18, 2025, Judge Catherine Morrison issued a 234-page ruling finding the Trump Organization liable for persistent fraud, conspiracy to commit fraud, falsifying business records, and insurance fraud. The judgment imposed a base penalty of $300 million for the fraudulent conduct itself, plus $150 million in disgorgement of profits obtained through fraud, totaling $450 million. The court also imposed operational restrictions requiring independent monitoring and pre-approval of major transactions. Judge Morrison's ruling gave Trump 30 days to either pay the judgment in full or post an appeal bond, covering the judgment amount plus anticipated interest. An appeal bond is a financial guarantee that ensures the losing party can pay the judgment if the appeal fails. Typically, defendants post property or securities as collateral, and a bonding company issues the bond in exchange for a fee and the security interest in the collateral. Trump's legal team immediately announced they would appeal, but appealing doesn't pause the judgment. To prevent enforcement during an appeal, the defendant must post a bond. That's where Trump's decades of inflating asset values came back to destroy him. Bonding companies evaluate collateral based on verified independent appraisals, not the inflated valuations Trump used to obtain loans. When bonding companies examined Trump Organization assets, they found that properties Trump had valued at hundreds of millions for financing purposes were actually worth a fraction of those amounts under legitimate appraisal standards. Multiple bonding companies refused to issue a bond backed by Trump Organization assets. They cited concerns about asset valuation reliability, the organization's documented history of misrepresenting property values, and the risk that Trump would attempt to transfer or encumber assets during the appeal process. By January 15th, the deadline for posting bond, Trump had failed to secure the required guarantee. That failure triggered automatic enforcement provisions in Judge Morrison's order. On January 16 at 6 a.m., federal marshals received authorization to begin seizing Trump Organization assets sufficient to satisfy the $450 million judgment. The seizure list prioritized high-value, easily transferable properties that could be sold or placed in receivership without complicated legal disputes. Trump Tower was the first target. The 58-story building on Fifth Avenue between 56th and 57th Streets is perhaps the single most iconic property associated with Trump's brand. It houses luxury retail, office space, and residential units, including Trump's own penthouse. The building has been valued in Trump Organization financial statements at figures ranging from $500 million to over $1 billion, depending on the purpose of the valuation. Independent appraisers commissioned by the court valued the property at approximately $380 million, accounting for existing mortgages and market conditions. Federal marshals arrived before business hours to minimize disruption and prevent Trump from attempting to interfere with the seizure. They presented court orders to building management and security, established federal control over property access, and began the process of transitioning management to a court-appointed receiver. Residents and commercial tenants were informed that their leases would be honored and that the seizure would not affect their occupancy, but that the property was now under federal court jurisdiction. By 9:30 a.m., news helicopters were circling Trump Tower, capturing footage of federal marshals outside the building and court-appointed receivers entering to assume operational control. The visual of federal law enforcement taking over Trump's signature property sent immediate shockwaves through financial markets, political circles, and the real estate industry. At 11:15 a.m., federal marshals arrived at the Trump National Golf Club in Bedminster, New Jersey. The property, which Trump has used as a summer residence and frequently visited during his presidency, encompasses over 500 acres, including an 18-hole championship golf course, clubhouse, and residential facilities. Trump Organization financial statements had valued Bedminster at figures exceeding $200 million. Court-commissioned appraisals placed the value at approximately $120 million, accounting for operational costs, outstanding liens, and realistic market conditions. The Bedminster seizure was particularly significant because Trump stores substantial personal property at the location, and because the property has been a center of his post-presidency activities. Federal marshals established control over club operations, informed members that their memberships would be honored under new management, and secured areas containing Trump's personal belongings, pending legal determination of what constituted organizational assets versus personal property. At 2:45 p.m., proceedings began to assume control of the Trump International Hotel in Washington, D.C. The property, located in the historic Old Post Office building on Pennsylvania Avenue, has been controversial since Trump took office because it created potential conflicts of interest with foreign governments and special interests renting space to curry favor. The Trump Organization holds a long-term lease on the property from the General Services Administration. The lease itself has significant value, and the operations generate substantial revenue. Court appraisers valued the lease and operational assets at approximately $90 million. The D.C. seizure was complicated by the fact that the underlying property is federally owned, and the Trump Organization only leases it. federal marshals coordinated with GSA officials to establish a receivership structure that would allow continued hotel operations while transferring management control and revenue streams to satisfy the judgment. By the end of January 16, federal authorities had taken control of assets valued by the court at approximately $590 million, more than enough to cover the $450 million judgment, plus anticipated legal costs and interest. The receiver, appointed by Judge Morrison, a prominent forensic accountant and turnaround specialist named Robert Chen, assumed responsibility for managing the properties, collecting revenue, and eventually selling assets as necessary to satisfy the judgment. Trump's response was immediate and explosive. He posted a series of statements on Truth Social calling the seizures an illegal government takeover of private property and the worst example of judicial overreach in American history. He claimed the properties were worth far more than the court's appraisals suggested, and that the entire process was designed to destroy him financially. He threatened massive lawsuits against everyone involved and insisted that the appellate courts would overturn everything. But legal experts were quick to emphasize that this wasn't government overreach. This was standard enforcement of a civil judgment. When a defendant loses a fraud case, refuses to pay, and cannot post an appeal bond, courts are authorized to seize assets to satisfy the judgment. The process follows established legal procedures that apply to any defendant, regardless of wealth or political prominence. The financial implications of these seizures extend far beyond the immediate loss of 3 properties. The Trump Organization's business model has always depended on the Trump brand representing success, wealth, and power. When federal marshals seize your most iconic properties, that brand narrative collapses spectacularly. Banks and lenders are reassessing their exposure to Trump Organization debt. Multiple financial institutions hold mortgages or credit lines secured by Trump properties. Those lenders are now looking at collateral that might be substantially overvalued and at a borrower whose flagship assets are being seized by federal authorities. Several banks have reportedly sent notices of default review, which is the first step toward calling loans or demanding additional collateral. Business partners and licensees are terminating relationships. The Trump name has been licensed to properties around the world, with developers paying fees to use the brand. When that brand becomes associated with fraud judgments and federal asset seizures, it loses its marketing value. Multiple licensing agreements are being terminated or renegotiated, cutting off revenue streams that the Trump Organization has relied on for decades. Potential buyers for other Trump properties are disappearing. If you're considering purchasing a Trump-branded property, watching federal marshals seize Trump Tower makes you question what you're actually buying. Is the Trump name an asset or a liability? Will association with Trump hurt your property's value? The answers are increasingly clear, and they're devastating for anyone trying to sell Trump Organization assets. The receiver's first priority is stabilizing operations at the seized properties. Robert Chen and his team must ensure that Trump Tower residents and businesses continue operating normally, that Bedminster club members receive services they've paid for, and that the D.C. hotel maintains its operations and guest services. This requires immediate cooperation from hundreds of employees who suddenly find themselves working for a court-appointed receiver rather than the Trump Organization. According to sources familiar with the receivership process, Chen's team has already identified numerous financial irregularities at the seized properties. Revenue has been systematically diverted from property operations to other Trump Organization entities. Expenses have been inflated to minimize reported profits. Related party transactions have transferred value out of the properties without proper documentation or fair market pricing. These irregularities suggest that even as the fraud judgment was pending, the Trump Organization was attempting to strip value from properties that might be subject to seizure. If proven, such conduct could result in additional legal consequences, including criminal charges for fraudulent conveyance or obstruction of justice. The receiver is also discovering that the properties are encumbered by complex webs of debt, liens, and obligations that make determining actual equity values very difficult to determine. Trump Tower, for example, has multiple layers of mortgages, mezzanine financing, and other secured obligations. After accounting for all legitimate debt, the equity value available to satisfy the judgment may be significantly less than initial appraisals suggested. This creates a potential problem. If the seized properties don't contain sufficient equity to satisfy the $450 million judgment, additional Trump Organization assets will need to be seized. The court's order authorizes the receiver to identify and take control of additional properties as necessary. Mar-a-Lago, Trump's golf courses in Scotland and Ireland, his properties in Chicago and Las Vegas, all are potentially subject to seizure if the initial assets prove insufficient.
The political implications of federal marshals seizing Trump's properties are staggering. Trump has always presented himself as a successful businessman whose wealth and deal-making skills qualify him for political leadership. That narrative is being systematically destroyed by court-ordered asset seizures. Republican political strategists are in crisis mode. How do you campaign for a candidate whose signature properties are being seized by federal authorities? How do you maintain the image of success and competence when marshals are literally taking control of your buildings? The visual messaging is catastrophic. Trump's opponents, both Democratic and Republican, are already using the seizures in campaign messaging. Ads are being produced featuring footage of federal marshals at Trump Tower, with voiceovers asking whether Americans want a president who couldn't manage his own businesses without committing fraud. The attacks write themselves, and they're devastating because they're based on court findings and federal enforcement actions, not political spin. Major Republican donors are pulling back. Several prominent contributors who had supported Trump's campaign have quietly paused donations pending resolution of the asset seizures. They're concerned about association with someone whose business empire is literally being dismantled by court order, and they're questioning whether Trump can remain politically viable while facing such visible financial collapse. The Trump Organization's employees face an uncertain future. Thousands of people work at Trump properties worldwide. As assets are seized and placed in receivership, those employees don't know whether they'll have jobs in 6 months, whether their benefits will continue, or whether the Trump Organization will even exist as a functioning entity. Some are already seeking other employment. Key executives are being recruited away by competitors who sense opportunity in the chaos. The Trump family faces potential personal financial exposure. While the fraud judgment is against the Trump Organization as an entity, several Trump family members served as officers and directors during the period when the fraud occurred. They signed financial statements. They participated in valuations. They benefited from the fraudulent conduct. If the Trump Organization cannot satisfy the judgment, plaintiffs can potentially pursue individual family members' assets through what's called piercing the corporate veil, a legal doctrine that holds individuals personally liable when they use a corporation to commit fraud. Donald Trump Jr., Eric Trump, and Ivanka Trump all played significant roles in Trump Organization operations. If prosecutors or civil plaintiffs can demonstrate that they knowingly participated in the fraudulent valuation schemes, they could face individual liability. That means their personal assets, homes, investments, savings, could potentially be seized to satisfy the judgment if the organization's assets prove insufficient. The international implications are equally severe. Trump properties in foreign countries are watching what's happening in the United States and reassessing their own relationships with the Trump brand. The Trump Organization has licensing deals, management contracts, and ownership interests in properties in countries including Scotland, Ireland, Panama, Turkey, and the Philippines. Many of those agreements contain clauses allowing termination if the Trump Organization experiences certain legal or financial problems. Federal asset seizures almost certainly trigger those provisions. Foreign banks that have extended credit to Trump Organization entities are reviewing their exposure and considering whether to demand immediate repayment or additional collateral. Deutsche Bank, which has been Trump's primary international lender for years, is reportedly conducting an urgent review of all Trump-related credit facilities. If Deutsche Bank decides to call those loans, it could trigger a cascade of financial obligations that the Trump Organization cannot possibly meet.
The receiver has 60 days to stabilize operations at the seized properties and develop a plan for satisfying the judgment. That plan could involve several options: selling the properties outright, maintaining them in receivership, and using operating profits to pay down the judgment over time, or some combination of both approaches. Selling Trump Tower would be extraordinarily complex. The building contains retail spaces, office units, and residential condominiums. The Trump Organization owns some units outright, holds long-term leases on others, and has various management and service contracts throughout the building. Disentangling all these interests and selling them in a way that maximizes value requires sophisticated legal and financial expertise. Potential buyers for Trump properties face unusual challenges. Purchasing a property from a court-ordered receivership requires navigating complex legal procedures and accepting potential litigation risks if Trump challenges the sale. Moreover, any buyer must decide whether to maintain the Trump name and brand or remove it entirely and rebrand the property. That branding decision has major financial implications. For some properties, particularly luxury residential buildings in New York, removing the Trump name might actually increase property values by disassociating units from a politically controversial brand. For other properties, particularly golf courses, where Trump's personal reputation matters to members, removing the name could decrease value. The receiver must evaluate these factors when developing a sales strategy. Meanwhile, Trump has filed emergency motions attempting to block the seizures and halt the receivership process. His legal arguments center on claims that the original fraud judgment was erroneous, that the assets are worth far more than court appraisals suggest, and that seizing properties before appeals are exhausted violates his constitutional rights. Legal experts give these arguments virtually no chance of success. The time to challenge the judgment was during trial and through timely appeals with proper bonds. Once you lose at trial, fail to post an appeal bond, and allow enforcement proceedings to begin, you've exhausted your procedural options. Courts almost never halt asset seizures after enforcement has properly begun. Trump's best option at this point is finding a way to post the appeal bond retroactively, which would require coming up with $450 million in cash or securing a bond from a company willing to accept non-Trump Organization assets as collateral. But who would lend Trump that amount, given his demonstrated history of financial fraud and asset misrepresentation? Some reports suggest Trump allies are attempting to organize a syndicate of supporters to collectively guarantee a bond. The idea would be pooling resources from multiple wealthy individuals who remain loyal to Trump to create a financial package that a bonding company would accept. But that approach faces enormous practical obstacles. Few people want to put their personal assets at risk to guarantee Trump's debts, especially when those debts stem from a fraud judgment. The alternative is that the seizures continue, additional properties get taken if necessary, and the Trump business empire that took decades to build gets systematically liquidated over the next year to satisfy the judgment. That outcome seemed unthinkable just months ago. Now it's the most likely scenario. The Mar-a-Lago question looms particularly large. Trump's Florida estate is his primary residence and the center of his post-presidency activities. It's also potentially worth hundreds of millions of dollars. Florida has a homestead exemption that protects primary residences from certain types of civil judgments, but that exemption has limitations and doesn't apply to all debts. If the receiver determines that Trump Tower, Bedminster, and the D.C. hotel don't provide sufficient value to satisfy the judgment, Mar-a-Lago could be next. The political spectacle of federal marshals seizing Mar-a-Lago, Trump's personal residence and political headquarters, would be unprecedented in modern American history. It would also likely trigger a constitutional and political crisis, unlike anything we've seen. But if the law requires it to satisfy a legitimate fraud judgment, courts have the authority to do it regardless of political implications. Trump's criminal cases proceed simultaneously with these civil seizures. Federal prosecutors in multiple jurisdictions are pursuing charges related to classified documents, election interference, and obstruction of justice. Those cases don't depend on the fraud judgment, but they're affected by it. A defendant whose business empire is being seized by federal authorities looks guilty and desperate to juries. Prosecutors will inevitably reference the civil fraud judgment as evidence of a pattern of dishonest conduct. The next 60 days will determine the future of the Trump Organization and potentially Trump's political viability. The receiver will evaluate whether the seized properties can satisfy the judgment or whether additional assets must be taken. Trump will attempt every possible legal maneuver to stop or delay the process, and the American public will watch as federal marshals systematically dismantle an empire built on a brand that claimed to represent success and power. What's happening isn't a political witch hunt or government overreach. It's the enforcement of a civil fraud judgment through standard legal procedures. Trump had every opportunity to pay the judgment or post a proper appeal bond. He failed to do either. Now, the law is being applied just as it would be to any defendant who loses a fraud case and cannot satisfy the judgment. The seizure of Trump Tower, Bedminster, and the D.C. hotel represents just the beginning. More assets will likely be taken. The Trump brand will continue deteriorating. And the question facing Republicans is whether they want to nominate someone whose business empire is literally being liquidated by court order while facing multiple criminal trials. The countdown continues. Federal marshals have secured 3 properties. The receiver is evaluating what additional assets may be needed. And Donald Trump is learning that, eventually, even billionaires must answer to the law.